HSI-Africa, and one of the 3 founding members of the Animal Law Project. And it's my pleasure to lead us through this last session today, where we're going to talk about enforcement challenges. I think it's self-evident to everyone that we can have the most comprehensive, well-conceived law, but if we lack the institutional capacity to enforce that law, and if the enforcement mechanisms are not effective, culturally, legally, and socially appropriate, the law is not going to give us the required outcomes. So it's been said a few times today, but at the risk of being slightly repetitive, we obviously recognize that there are very committed people working tirelessly on the ground to enforce the law as it currently stands. And I'm hoping today our focus is not going to dwell on that so much, but to look at the institutional challenges that we face and how we might envisage a new regime that would protect animals, where the institutions are aligned, properly capacitated, where there is transparency so the sector can see what is happening, and where we can be responsive to useful data that comes back about where we are making impact and where we are not. So we have 3 speakers here in person and 1 online. Jacques Peacock from the NSPCA, Mickey Thesner, who has experience in the public prosecutorial space, Professor David Bilchitz, and Renel van Zyl from the Law Reform Commission. Jacques is going to open up the discussion for us. Jacques is a passionate advocate for animal welfare with a history in both law and animal welfare. He completed his LLB at the University of Pretoria, where he also served as the judge of the Constitutional Tribunal. His research efforts, whilst he was at that institution, focused on animal protection, specifically analyzing the Animals Protection Act. After a short stint at BDK Attorneys and some involvement with the SPCA movement since 2016, joined the National Council of SPCAs as Public Relations Officer in September 2023, and where he now serves as the Communications Manager since June 2024. Jacques.
Good afternoon, everyone. I'm the same as Dr. Sontag. I don't have slides. I have my trusty little notebook. Those from the office will know that's my only little thing that I carry with me. And if it ever goes missing, I have big trouble. Like Prof. Murcott has said, and full disclosure, I was one of her students. Clearly not the most memorable, but in my defense, she taught me right at the beginning of the pandemic. So yeah, no, not at all, not at all. But like she said, if you feel uncomfortable, that's okay. I don't think anyone in this room has at any stage today not felt a sense of discomfort, and that's fine. That being said, I don't believe that anyone is here or should be here to be on a rampage. It's not about my agenda or about your agenda versus your agenda, me against you or everyone against someone. It's what's in the best interest for the animals. When I asked my question earlier, I could already see some interesting facial expressions, and that's okay. Even in our own organizations, we fight a lot, but it's always about what's in the best interest of the animals in our own lived reality. Not one of us is right. There is no one correct answer, otherwise we wouldn't be sitting here. Then this problem would have been solved long ago. I'm not here to diminish any organization or to, and I quote, create further division, but to possibly give a different perspective of our lived reality, which I hope will be respected with the same respect that we all hope to give to animals. It was quite interesting that in the opening paragraph of this colloquium's concept note, the landmark Constitutional Court judgment of 2016, which found animal welfare to be a deep principle in the South African Constitution and connected it to the human right to have the environment protected, is used as the starting line for this event. However, what it does not recognize is that the historical judgment is the NSPCA's. We were the applicant for the animals. In the NSPCA's absence, the concept note for this colloquium would have looked very different, if at all, in existence. For those of you who don't know, the NSPCA is the statutory body for the welfare of animals in South Africa, and our purpose is twofold. Firstly, in relation to societies, SPCAs, local SPCAs across the country, to act as statutory body by determining, controlling, and coordinating the policies and standards of societies in order to promote uniformity, to promote cooperation amongst societies, and to promote the interests of societies. Further, in terms of Section 6 sub 1 of the SPCA Act, the NSPCA is for purposes of Section 8 of the Animals Protection Act, a society for the prevention of cruelty to animals, where we work for the welfare of all animals, not just domestic, but including wild animals, all farmed animals, including fish and crocodile who are farmed, animals used in research and education, working animals, and violent crimes against animals like dogfighting and bestiality. In more simplified terms, the NSPCA is the only regulatory body for animal welfare organizations in South Africa and the only inspectorate-based organization to work countrywide, authorized by statute to enforce the Animals Protection Act. We do not represent a political or ideological lobby, a university or theoretical model. We are the largest animal welfare organization in the Southern Hemisphere, operating along with our societies on the ground, in cities and in towns, informal settlements, and deep rural areas where we investigate cruelty, lay criminal charges, aid animals in need, and stand between them and unimaginable suffering. Yes, the manifesto sets out a bold vision to transform animal protection in South Africa, and on the surface, such ambition is commendable. However, as we all in animal welfare know, vision without grounding in reality can not only be unhelpful, but deeply damaging. The NSPCA was not involved in the drafting of the manifesto. This was not a matter of oversight, but a deliberate decision informed by the fundamental differences in principles and approach, particularly by two of the Animal Law Project's founding collaborators, Animal Law Reform South Africa, and which is now Humane World for Animals South Africa. These organizations have at various times opposed or undermined the NSPCA's work, including in soft law processes, but yet the manifesto still brands the NSPCA as a key stakeholder, a contradiction that sets the tone for what follows in the document. At the heart of our response is a concern with misrepresentation, not only of the NSPCA's role, but the broader realities of animal protection enforcement in South Africa. We are not just another charity. We are the only statutory body mandated under the SPCA Act. We possess policing powers under the Animals Protection Act and have a long-standing record of prosecuting cruelty, even against the state itself. We are also the only animal welfare organization in the country to have the right to privately prosecute offenders for animal cruelty, something, again, that we fought for. To depict us as merely a civil society organization with no real legal standing is not only misleading, it's a dangerous distortion that threatens the very framework of animal welfare in our country. The reality is, while many speak of animal law in the abstract, we apply it. While some develop policy proposals, we're in the field laying charges, seizing animals, and fighting in court against cruelty and neglect. We execute warrants, we crack down on cruel operations, we intervene in livestock transports, which we are trying to ban. We inspect all facilities utilizing animals, from entertainment to for consumption. The manifesto solution, then, to possibly dilute the current enforcement model and create a government-run animal protection office. On paper, it sounds progressive, first in the world. In practice, it is profoundly detached from South Africa's realities. The state already struggles with existing enforcement responsibilities, from policing to environmental protection. to suggest that animal protection can be handed over to the Department of Justice without any roadmap or feasibility analysis is not visionary. Quite frankly, it's reckless. And I know we are far from perfect, and we welcome good faith criticism. And I want to tie into what Dr. Sonntag said. Like the vets, we try the best we can with what we have and are then criticized. While we welcome good faith criticism, the manifesto stone borders on adversarial. It fails to recognize the successes that have been achieved, often under immense constraints. It ignores the fact that local SPCAs are independent bodies run by volunteers because they love animals, not centrally controlled. It overlooks our victories in courtrooms, in parliament, and on the ground. The manifesto ignores that it is only the NSPCA to help animals in need on the ground nationwide. For those of you who may have followed, where were our teams the weekend before last week, and even today? The only organization to prevent suffering of literally hundreds of thousands of chickens. Our whole team was there. Even my fundraiser, who moved from George, she started with us a month ago. She was there to help because we all buy in. We are the organizations who so easily criticize the NSPCA and the SPCA. In essence, the manifesto confuses a theoretical framework with a functioning system. It's easier to write sweeping reforms than to enforce a warrant at a line farm, where the nearest SAPS van is 1 hour away. It's easier to call for centralization than to pay salaries from donations. We therefore submit, and if you take away anything from what I've said today, I hope that it's this, that any conversation about legislative reform must begin with enforceability. If it cannot be enforced, it cannot protect animals. If it duplicates functions that already exist, it weakens, it doesn't strengthen the system. If it romanticizes new governance frameworks that have no financial or institutional framework or scaffolding, it distracts from the real work and the real suffering that continues daily across the country. The NSPCA doesn't oppose the evolution of animal protection legislation, animal welfare legislation, whatever you may call it. On the contrary, the NSPCA has long before some organizations in this room have existed, advocated for improvements in legislation, greater accountability, and stronger public awareness. But we must insist that such reform be practical, inclusive, and above all, realistic. Change must be credible, it must be pragmatic and anchored in the institutional realities of South Africa, not in frameworks that might work in other countries with strong state inspectorates and consistent funding, but which cannot be imported wholesale into our country where the enforcement burden currently sits with a non-profit statutory body. We must also be careful not to confuse the welfare of animals with animal rights. They are not the same in law or practice. Welfare is enshrined in legislation, it is enforceable, it allows us to prosecute. Rights, while very aspirational and inspiring, it is, I promise you, do not exist in our legal framework, or for that matter, in any legal framework in the world, in a way that allows for direct enforcement. When policy proposals blur this line, they risk creating a vacuum, in which neither role is properly upheld. We must be careful of pretending that we can build a new enforcement mechanism from scratch. The manifesto's greatest flaw is not its idealism, but its detachment from implementation. It critiques but does not construct. It condemns but does not practically view. So where do we go from here? The NSPCA is open to dialogue, but it must be dialogue based on mutual respect, shared commitment, and lived experience. We invite those with legal and policy expertise to walk in the field with us, to see the cruelty we face daily, the voids we try to fill, and the human resistance we overcome. The focus here should be the animals, not egos or institutional posturing, but the animals whose lives depend on our work. Thank you very much.
Thank you, Jacques, for that comprehensive and passionate presentation. I really am sincerely pleased that you came and you spoke frankly about what is on your mind as an institution. And I think that is an important part of the process of both this colloquium and the general law reform initiative that the Animal Law Project has embarked on. From your short presentation, I can see there are a number of quite significant misunderstandings about where the manifesto is aiming and what we're doing, but I do value your comments and your suggestions that you're open for dialogue, and we will certainly be seeking to engage with you further to iron out those misunderstandings and try and forge a considered and constructive way forward that addresses the challenges that you've set out. So thank you very much for your contribution there. Our next speaker is Mickey Tesner. She is the co-founder of the Wild Vegan Farm Animal Sanctuary out near Johannesburg, a non-profit which was established in 2021, where she and her husband as co-founder care for over 150 traditionally farmed animals with a special focus on equines. She has also served on the board of directors of the Friends of Rescued Animals, NPC, from 2012 to 2020, where the focus there was mainly on companion animals. But she's really here today to talk from her legal experience. She has a B.Proc degree from this institution and has served articles of clerkship with the Legal Aid Board until joining the erstwhile Department of Justice as a prosecutor in 1999. Mickey has since appeared in district, regional, and high courts across the country, the majority of her experience in the prosecution of serious and violent crimes and other high-profile matters. Mickey, I'm going to bring you online. Can someone help me get the Mickey?
Okay.
Thank you.
Can you hear me?
Yes, we hear you loud and clear.
Just wonderful. Okay.
Just trying to get
wonderful.
big. There we go.
All right. Can you guys hear me?
Yes, please go ahead.
Okay, perfect. Thank you. Okay, thank you. Yeah, the best I can do at this point, and I do hear what my learned colleague there from the NSPCA is saying. I do in the instance agree that we do need an enforceability vehicle to be able to make a new law work. What my experience in the courts has taught me over the last 27 years is that the problem is not generally with legislation. I think in the animals protection or the animal welfare sphere, possibly the legislation is a bit of a problem in the light that it is so old, etc., etc. But you can have the greatest piece of legislation, and at the end of the day, if you don't have the vehicle with which to enforce it and its various components, then you are going to struggle at the end of the day. So my contribution then to this colloquium, if you will, then would be to give you a bit of perspective of what is going on at this point and what you can expect on the side of either side of the fence, really, whether you are an accused or whether you are a complainant, with regards to what is physically going to happen in court. My feeling at this point with regards to certain ideas, etc., with regards to making it better, is that you've got to work with the system you've got. You've got to work with what you have, because you can't, at the end of the day, change the system overnight. I do think training is very important. I do think training on all sides is very important. But my contribution here would more be on a discussion level and on a practical level of what can be expected in the criminal courts. So I don't know if there's anyone who wants to know anything else, but that's where I am today.
Yeah, thanks, Mickey. That's exactly what we'd like you to talk about. So please do go ahead and share some of those thoughts.
Okay. So what we find at this point in the current system is that a lot of the prosecutions that do proceed, do sort of end up in the district courts, which are kind of like the starting point for prosecutors and magistrates. So The general starting point is that you've got inexperienced prosecutors and inexperienced magistrates. So interpretation of law and dealing with law of evidence and exhibits, et cetera, you know, might turn out to be challenging. So I think that is one of the first stops that possibly have an impact on successful prosecutions. I do think that prosecutions do have to be limited to the evidence that you can gather at the end of the day. What we found, what I've dealt with some matters is that we do have animal organizations who do not stay within the parameters of the Criminal Procedure Act as far as search and seizure is concerned. Section 8 only allows you certain, certain powers, and it has to be done within the framework of the Criminal Procedure Act. If you are sitting with an unlawful seizure or a warrant that is not executed correctly or was not obtained correctly, you cannot present that evidence. So at the end of the day, when you are looking at a successful prosecution, you have to start at the very least with the enforcers on the ground, either the police service or one of the organizations then mandated by Section 8. But again, these boundaries I found is very often overstepped, which makes it difficult to proceed with a successful prosecution. And then at the end of the day, the question you have to ask yourselves, we had a matter specifically in our court where a local animal shelter was involved. And yeah, the concern at this point is, I think they can be very grateful that there was a plea of guilty tendered, because there was a lot of mistakes that were made on that side as well. But he was indeed convicted. He was indeed sentenced to prison. It was a guy that was selling, I think it was puppies or tortoises or something like that on the side of the road. And then eventually there was some jail time. But this, at the end of the day, although it was publicized a lot, and of course this is the often used as a vehicle to get further donations in, et cetera, look at what we're doing. But the concern is, at the end of the day, is it a win? And that was where my concern lied, because as soon, obviously, as the sentence had been served out, the guy was right back on the street doing it again. So at the end of the day, you have to look at possibly a better understanding, I think, from both magistrates and prosecutors, possibly, to have a bit of forward thinking as far as punishments are concerned, and as far as sentences are concerned, and as far as which cases do you take on trial, which ones at the end of the day are going to get you the results you want, and get you the outcomes you want. So that I do think is a specific area in which there can be some improvement, because, like I said, you do deal with inexperienced prosecutors and inexperienced magistrates, and I do think that non-profits can certainly benefit from legal training. Definitely having legal training themselves, specifically with regards to search and seizure, and specifically with regards to the execution of warrants, with civil arrests, with regards to detaining, perpetrators, etc. So those things just make the prosecution process at the end of the day a little bit easier. But it is difficult. It is difficult to engage with the different role players in the criminal justice system at this point. It is difficult. It is difficult to get the cases to eventually land on a prosecutor's table, because most of them end up as decision dockets. That's lying somewhere in the dusty corner of somebody's office that eventually is only gotten to. So there isn't really a sense of massive urgency with regards to these matters. So it is going to be a battle to get it into the court system. And then when you are in the court system, you are going to have to sort of have a massive dedication to see the matter through to the end, and then ask yourself if the outcome you are desiring at the end of the day is going to be the one that is found in the criminal courts. When I started my degree in 1997, or at least in 1994, one of our first law professors said to us that the last place that you'll find justice is in a court of law. So, and 27 years down the line, I wonder how much of that does ring true, because I think it does to a certain extent, it can. So I do think that various parties definitely can benefit from training and can benefit from knowing what you're getting into, definitely, when you are entering into the criminal justice arena. Okay. Don't know if there's anything else anybody wanted to know.
Yeah, thank you, Mickey. I think you're speaking quite practically about some of the difficulties with having a criminal-only remedy for animal cruelty, a criminal law remedy only. Amy touched on it, and we've heard it a bit earlier today. Not only the challenges with the burden of proof and a disinterested and incapacitated state generally, but also on occasion over-exuberance from animal welfare organizations that then contaminates and compromises the case. So, perhaps criminal law is best served for large-scale animal cruelties where the reward of the investment of time in process is going to yield changes in behavior. And, for people who chain a dog cruelly and so on, it seems like a very large hammer that you swing for a long time. Correct. And in fact, during our ALP process, another person on our expert panel said to us that their experience has been that, administrative law fines and confiscation of the animals carries with it much more social consequences for animal abuse than the criminal law process, because the ultimate sanction is often very disconnected from the activity, both in time and in the messaging. So, but you have spoken about things that we can address. Some of these problems exist within the state system, right? We can ask for stronger sanction, and we can work to try get animal cases more priority in the courts. There are things that we as a sector can do there. But I think there are, also things like educating the police and working with persons like yourselves and the National Prosecuting Authority and elsewhere. These are practical things that we can aspire to, and that in our work, we've realized that these are key enablers if we're going to be able to make the law effective in our ultimate ambition of protecting animals better.
Yes.
So thank you, Mickey. Is there anything else you'd like to add?
No, thank you. That's all. Thank you.
Okay. Well, thank you very much for speaking so practically. I think that's some very useful feedback. I'm just going to ask Amy to fix the IT. Our next speaker is Professor David Bilschitz. He's been here the whole day and he was introduced to us earlier. So I'm not going to take you through his background again. I'm going to hand over to him, and then we will finish up with Ronel Patel. Thank you.
Great, thank you very much. And there are a range of overview of role players in the enforcement issue, which has been raised. As we heard about the police, the National Prosecuting Authority, the NSPCA, the SPCA movement, the courts, veterinarians, pound masters. And what I'm going to talk to you today about is two of these. Firstly, a governmental body, department, which is tasked with engaging with animal welfare, DALRID, and I'm going to talk to you about some of the issues. And in the spirit, given we've had a very spirited engagement from Jacques, I'm going to offer my own critique of the SPCA Act as it currently stands. So the Department of Agriculture, Land Reform and Rural Development is the department tasked with oversight over animal welfare, and it's failed adequately to exercise its authority in this area. I think it's fair to say. It's given the mandate in Section 10 of the Animals Protection Act to issue regulations on several matters, including any other reasonable requirement which may be necessary to prevent cruelty or suffering of any animals. My time. And to date, there are very few regulations that have been promulgated in respect of Section 10. This has led to major gaps in the regulation for a number of practices. There are lack of proper standards for care, prescribed provisions for animal welfare and treatment. It has also led to an environment of self-regulation for many animal uses and voluntary types of regulation, etc. And there's been a failure to incorporate international standards, for instance, by the World Organization for Animal Health. On major institutional issues in the department, there is no budget line on animal welfare. There's lack of a proper policy framework on animal welfare. There's no assessment or performance measures in this regard. And from a prior request, it was clear that it's a totally undercapacitated area of the department's work. There are only 5 employees partially assigned to animal welfare, and there's no one dedicated person responsible. In fact, someone was telling me over lunch that the part of the problem with this process of the animal welfare bill is someone gets promoted and then someone else comes in, and the process keeps getting delayed, etc., because of the way these things work. There's no proper inspectorate, there's no transparency on its efforts in relation to welfare, and no proper regulations on enforcement measures. And the process for the new animal welfare bill has failed to include representatives of the animal protection sector, and there's a lack of a cooperative governance framework with the Department of Forestry, Fisheries and the Environment and the Department of Justice and Constitutional Development, which all have a degree of overlapping mandates with this area. So the argument that I'm going to present to you, some of it's in the manifesto, but some of it's not, is that there's similar problems we're seeing in Australia, with the agency being in the Department of Agriculture. And there's a very good article by Jed Goodfellow, who engages with the problems that we're seeing in Australia, and I think they're similar here. And he engages with this idea of regulatory capture, which he argues is a process by which a government agency acts in the interests of individuals, firms, or industries charged with regulating in a way inconsistent with the public interest it is designed to achieve. There's often a private distortion of public purposes. Often those biases are not conscious or deliberate, nor are they illegal or deliberately corrupt. But the design of the institution contributes to this, including a conflict in the mandate. So you need to regulate an industry for harms and then promote that very industry. And there's often also a cultural capture that takes place of government departments. Agencies have common backgrounds and personnel with experience from the industry. So what is the conflict in DALRRD itself? Well, it must promote productivity and welfare, but they often conflict. And so the Department of Agriculture generally rewards productivity of animals over welfare. Often it was thought that animals couldn't be productive if there was poor welfare. That's not true. Animals can be productive despite poor welfare, unfortunately. And the idea for many in industry is to reduce the costs of welfare to the bare minimum. And so there's a boosting of animal agriculture responsible for so much suffering, and issues like live export of animals, which we must give great credit to the NSPCA for taking on the issue, unfortunately not leading to a positive result. But that was showing the prioritization of industry over welfare. Okay, the focus on, there's also in this department obviously going to be a focus on agricultural animals. And of course, the whole domain of animals includes companion animals and wild animals. So it doesn't make so much sense. And this leads to a whole range of regulatory failures, the overrepresentation of industry interests, industry influence over the development of animal welfare science, and inadequate compliance and enforcement, mostly self-regulation and very limited punitive sanctions. How do we reform it? There are 3 possibilities that Goodfellow mentions. The first is separating out the conflicting responsibilities in a public agencies. So DALRRD gets responsibility for productivity, and you separate out a different animal welfare agency or place in another department, right? The manifesto suggests the Department of Justice and Constitutional Development as criminal law and vulnerabilities already contained within, and place a dedicated animal protection office. And I should say, I don't think that the idea of that protection office is necessarily to replace the whole NSPCA structure. I think the goal is to actually manage the element that is necessarily in government, must have dedicated resources for that purpose. The second possibility is to have an independent agency that monitors the performance of a department. So to have something like an ombudsperson for animal welfare to create a check on the agency, but that's still less desirable as it creates, there's still conflicting functions in one of the agencies. And the third is what's called tripartitism, which involves bringing in a range of different actors like prominent NGOs, giving them information that's available to the agency, granting them a seat at the table when matters are negotiated, and allowing them to prosecute as the regulator at times. To some extent, the latter model has been adopted in South Africa with the SPCA Act, And so we need to evaluate to some extent the SPCA movement, which has been given these tasks, some of these tasks formally. So I'm now going to talk a little bit to the NSPCA and SPCA movement. And I'm going to start by saying I recognize the central and important role played by the SPCA movement in South Africa. I'm glad we have representatives from the movement today, and recognizing also the very important work. So I'm not sure where Jacques got the notion that people don't like and recognize the important work that is being played by the societies, the individual societies. I think many of us come into contact with in geographical, close to us, in dealing with the adoption of unwanted or stray animals, providing veterinary services, engaging in a range of educational programs, and the National Council of SPCAs, amongst many activities, inspects, as we heard, facilities that house animals in the meat and dairy industry, and recognizing the terrible expose of chicken suffering at Daybreak Foods, inspects facilities that hold wild animals in captivity, and makes inputs to legislation and policy at national and regional levels. There are, of course, many other organizations that are involved in protecting animals and advocating for them, and of course we could look into them, but the role of the SPCA movement deserves special attention, given there's a specific piece of legislation that has been devoted to it, namely the Societies for Prevention of Cruelty to Animals Act. And as I said, in the spirit of open engagement, also in the lack of research actually into the Act, there's virtually, I didn't find one article written on this in academic sphere, and I'm currently trying to change that. It seems to me there's a need to change this law too in any revision of the Animal Protection Act. So why is it? Well, of late, at least 3 recent cases have reached the courts concerning conflicts between the NSPCA and the individual societies. In 2020, there's a case of the societies against the NSPCA for taking enforcement measures that would have prevented them from voting at the AGM. That case was withdrawn before it could be heard, but on affidavit, there's a range of very concerning things that are mentioned. In 2025, just at the beginning of this year, there's a judgment that was taken against the NSPCA for taking over the Tshwane SPCA and excluding the leadership from its premises. Again, as you'll hear, they're very concerning issues that arise from that judgment. And just about a few weeks ago, there's been an institution of an action by the Tshwane and Bethlehem SPCA seeking to compel the Minister of Agriculture to exercise his powers of oversight over the NSPCA. Now, this litigation, I would argue, detracts from the primary mission of these organizations, which is to protect the welfare of animals, and it focuses on internal conflicts within the movement. And there is a broader question that we need to think about the nature, structure, and composition of institutions which are tasked with protecting vulnerable animals from human abuse. And it's critical we evaluate those issues when thinking about law reform. In my view, there are clear conceptual incoherences in the structure of the NSPCA in the SPCA Act relating to the nature of the body, its funding, and its powers. And I'm going to focus on 2 of these. I'm just going to mention briefly that this legislation was also passed before the New South Africa, right at the end of 1993. I don't understand the complete reason why this was rushed before the New South Africa. It would be interesting to understand the background to that, but it received the support of the Nationalist Party, the Conservative Party. It did not receive the support of the Democratic Party at the time. And I actually went back to some of the discussion of the debate in Parliament. So what's the central incoherence in the Act? Essentially, I would argue it enshrines 2 mutually incompatible functions in the body. The first is a conception of the NSPCA as an umbrella body. So this conception of a national body is the notion that it is really an outgrowth of local autonomous societies seeking to cooperate. That national body is an umbrella body which they co-create to enhance their work. That conception in turn naturally leads to the idea that the national body is composed of representatives from the societies who wish to work on the national level and who are accountable to those societies. However, the Act also enshrines the idea of the NSPCA as a regulatory enforcement body, not in relation to animal welfare per se, but over the other societies. It can impose rules and policies on those individual societies, and it provides powers of enforcement, extraordinary powers of enforcement, to the NSPCA against individual societies, including replacement of management committees, removing individuals, cancelling their registration, dissolving the societies, and transferring the assets of those various societies. Now, in my view, these two functions are simply incompatible. The umbrella function involves representation. It involves coordination. It involves pooling resources. It involves the NSPCA as an outgrowth of the movement, a bottom-up notion of the NSPCA. And if the NSPCA is to succeed as an umbrella body, it would need to restrict its role as a regulatory enforcement body over other societies. On the other hand, if it functions as a regulatory enforcement body, its role as an umbrella body is undermined. The enforcement element leads to tensions and conflicts. It encourages a separation between the two and a conflictual relationship between the two, essentially leading to a top-down conception of what the movement involves. So enforcement, for instance, allows the NSPCA to control the very makeup of its own AGM through denying societies who are supposed to be its members a vote if they are not in what's called good standing. And the papers in a recent court case indicate that only 17 SPCAs were in good standing of 67 SPCAs. And in the 2020 case, the NSPCA showed that in its own admission, in its responding papers, it says that only 20 out of the 75 societies at the time, that's about a quarter, were found not to be in good standing and so could not vote at the AGM. That has seriously undermined its role as an umbrella movement and undermines its claim to be the national representative body of the individual societies. The NSPCA, and this problem also arises and leads to another serious conflict around funding. The NSPCA does not generally have state funding. It has to fundraise for funds, which places it in some competition with local societies. Although mostly it doesn't receive state funding, there's an exception in relation, most don't, but in relation to municipal pound function. But the extensive powers of enforcement are granted to the NSPCA over the societies, as I mentioned to you. So the NSPCA may approve the registration of new societies, but the Act also allows the NSPCA to perform the role of an individual society. So why would you approve the role? I'm not saying the NSPCA has not done this, right? But I'm saying this is a fundamental tension in the law itself. Why would you approve a potential competitor when you can yourself perform that very role? It can also benefit from the closure of societies, including through enforcement actions, and take over the sources of their funding. And unfortunately, in the Tshwane case, there was a damning finding by Wenzel AJ. He said that he suspected that the real reason for the takeover of the Tshwane SPCA had more to do with the control over the donated funds than it was about the alleged mismanagement of the donated funds, right? I'm quoting from the judge. I'm not making any judgment. That's what the judge found himself. There's also an extraordinary provision which provides that if the board decides to undertake any campaign, investigation, or proceeding which is of national relevance or is important to the objects of the council, as well as those societies or certain societies, the board can, by ordinary resolution, require the societies to pay a contribution to defray the cost thereof proportional to their general contributions. So this extraordinary provision allows the NSPCA completely to upset the budgetary planning of individual societies by creating a national campaign in terms of this provision and then forcing them to contribute to the funding thereof. And I know there has been some proposals in the movement to try and address this problem. So how do we address this problem? The solution to this problem, in my view, is to remove the regulatory enforcement power from the NSPCA over individual societies. In doing so, it could return to a focus on its role as an umbrella organization to provide greater voice to the collective aspirations of individual societies. Doing so would allow the NSPCA to fulfill its role of providing national representation for the societies and be accountable to them as to how it performs that role. It would entail that the NSPCA is an outgrowth of the individual societies rather than being an imposition upon them. Its role would be supportive, advisory, nurturing, rather than punitive. It would also allow the NSPCA to focus on its work of protecting animals in parts of the country where there are no societies, which is clearly a very important issue. and it would also reduce the issue of conflict over funding. The NSPCA is not placed in a position under that conception to control the funds of individual societies or utilize its powers in terms of the Act to gain access to funding of those societies. And so that's a particular reform that I think is very critical to try and ensure the greater and important functioning of the SPCA movement. But this raises the question of the reform of government institutions, which hopefully leads to a stronger role for a range of institutions, right? One could think that we would like the government to play a stronger role. I actually agree with Jacques here. We must take account of the general issues of incapacity in government and the unlikelihood in the near future of animal welfare being a priority. That's not something we should be proud of, but that is the current state of affairs. If we're going to continue with an organization like the SPCA, and NSPCA, one needs to think of what are the critical powers that need to be included in such a movement or in such a body. It seems to me the powers of investigation, search, seizure, and arrest, private prosecution, as you mentioned, the 2016 case, perhaps the setting of training standards for inspectors nationally, and an advisory role in relation to generating regulations or legislation could be some of the functions that I would think of. It is also important to say, even though I focused on the SPCA movement, that there are a range of different animal protection organizations, and one needs to avoid sidelining those other organizations and taking account of diverse perspectives, perhaps in the composition of the entity. Because ultimately, and I think someone said this earlier, the key is the unity around protection of animal welfare. There has been, unfortunately, a degree of tension in relationships between the SPCA, particularly the NSPCA, and certain other animal protection organizations. And instead of a conflictual relationship, how much could we achieve together if we move towards a much more cooperative relationship and to find a way to work together in the interests of other creatures? So that's where I'm going to leave it over here, and then we can have a discussion. Thank you.
Thank you, David, for that comprehensive analysis. I'm sure there are lots of thoughts and questions. Before we go to our last speaker, I'd like people perhaps just to reflect a little bit on what Karen Trendler said earlier. When we talk about conflict and industries that we are seeking to reform, and how well they are organized, and how well they present their case to government, and how effective that is, and how much further we've got to go as organizations in order to build a coherent vision which allows us to contest that political influence and demand the type of reforms that we might engender from these sort of discussions. So I think today is an important first step where we can ventilate some of these issues and we can start to work towards a combined vision where we can, in fact, move forward and deal with some of the structural impediments that have frustrated us in the past. Our last speaker for the day is Ronelle van Zyl. We heard Justice Colloquium speak warmly of her earlier during his presentation. She holds a B. Juris LLB and LLM from the University of Pretoria. She is the State Law Advisor and Researcher at the South African Law Reform Commission. The object of that institution is to do research on and study and investigate all branches of the law in South Africa in order to make recommendations for the development, improvement, modernization, or reform of law. Before this role, she worked in the Department of Agriculture, now DALRID, first as a legal administration officer and later as head of legal services. Legal services is responsible for providing legal advice and support to the department, as well as the drafting, vetting, and amendment of legislation and subordinate legislation administered by the department. The legislation in question here would have been the Performing Animals Protection Act, Animals Protection Act itself, Animals Diseases Act. Ronelle personally is a lover of all animals and contributes to WWF, Greenpeace, works with the South African Wildlife Rehabilitation Centre, and is a member of the Spider Club of South Africa. Welcome, Ronelle.
Thank you. That just goes to show that, not only the furry ones are animals. I'm very fond of spiders. There was a presentation, but it is okay. Okay. Okay, thank you. So what I've done, I've taken a cue from a meeting that I had where we discussed basically how legislation works and the background on how legislation gets adopted and passed through Parliament and so on. So that's what I'm talking about. And I also want to mention some issues that might help in this journey of getting appropriate animal legislation on the table. So obviously the currently now in main legislative authority is derived from the Constitution. And Section 44 specifically talks about the National Legislative Authority, which is vested in Parliament, and it confers on the National Assembly the power to amend the Constitution to pass legislation with regard to any matter, including a matter within a functional area listed in Schedule 4. Now, there's quite a complicated system in Parliament to decide, you know, when is something national legislation, when is it provincial legislation, because there are different procedures in terms of Section 75 and 76 of the Constitution, and when is it monetary legislation. So I'm not going to bore you with that. Agriculture is a shared function. It's shared between national and provincial. I do not know how the proposed animal welfare bill was tagged. I think it would probably be a mixed bill, and I'll explain a bit later. I'm going to draw some comparisons to the Children's Act, which I was involved with for a long time. I'll explain why I think looking at the Children's Act might be useful in this regard. So there it's basically what Schedule 4 is about. Justice Colloquium mentioned it earlier. The Schedule 4 lists the functional areas of concurrent national and provincial legislative competence. And in there, there's agriculture, there's animal control and diseases, and then there's nature conservation, which excludes national parks, obviously. So all the provincial nature conservation efforts are mostly, I believe, you know, the systems of permits and licensing are mostly done by the provinces. I know that can be problematic sometimes. And then coming to the executive authority, which is the president and the cabinet. So the president exercises the executive authority together with the other members of cabinet, and they do that by implementing national legislation, by developing and implementing national policy. And people that knows how legislation works will know that there's normally a policy that precedes a legislation, not in all instances. Sometimes the policy will cover an area of the law, and then the legislation will pick up on certain things. And not all policy results in legislation, but if you want to enforce it, there was a constitutional court case about that, you have to incorporate it into legislation. So they're also just responsible for coordinating the functions of state departments and administrations, and then preparing and initiating legislation, which is what we want to function on today. So in terms of animal welfare, as we've repeatedly said today, it's currently the Minister of Agriculture, and here they've split the portfolio. So they've split the Minister of Agriculture from the rest of the portfolio. So there's no longer one minister that covers agriculture as well as land reform and rural development. They've split it off, but the animal welfare part falls under agriculture. So legislation under agriculture, and there's a reason why I listed these particular ones. There's the Performing Animal Protections Act, and that deals with like circus animals, for example, you know, sort of almost animals that work for a living, guard dogs, circus animals, that type of thing. And you can see it's a very old piece of legislation. And the other one is the Animals Protection Act of 1962. And what the reassigned in brackets mean is that these two pieces of legislation did reside with the Department of Justice in the past. If you look at the content of the legislation, the definition of minister there is Minister of Justice. And in the 90s, The president has the power to, by proclamation, reassign legislation or acts between different ministers, different members of cabinet. And that's what happened in the case of the Performing Animals Protection Act and the Animals Protection Act. Both of them were reassigned, and it was withdrawn from Justice, and it was reassigned to the Department of Agriculture. And I think the reason probably why it was with Justice in the first place, Justice is sort of the dumping site, I almost want to say, with anything that's related to criminal law. Justice by far administers, or the Minister of Justice is responsible for the greatest number of acts and legislation, not because it's necessarily actively being enforced by the Department of Justice, but because it ends up there if it's sort of remotely related to justice in any form, and there's no other line functioned upon. I can mention something like the Matrimonial Property Act and the Marriage Act. The Marriage Act is under the Department of Home Affairs. Matrimonial Property Act is under Justice. So and the Family Advocates is under Justice. So there's sometimes a bit of a conflict almost about where exactly do you what is the home of a piece of legislation. And now, as we've seen over the past few years, the portfolios of ministers change, and that creates problems down on the ground, because sometimes you have to transfer people and you have to transfer budgets between departments, and then a few years later it's reversed, and then you have to do it all over again, so it can be quite problematic. Veterinary and Paraveterinary Professions Act was also mentioned before, and there's also a specific reason why, I will get back to that, why I'm mentioning it. Agricultural Pests Act, why I have this here. It's not only water hyacinth, which is an agricultural pest. There are animals which are considered as agricultural pests, like locusts, and red-billed quail. Millions of red-billed quail, if they attacked a field of wheat, there's nothing left of the harvest. So they actually have methods where those swarms can be in the millions, hundreds of thousands of millions of birds, and you can exterminate them. They poison them, they spray them, they catch them in nets. So that's why I'm mentioning it here, because one wouldn't think normally that the Agricultural Pests Act also does have an animal welfare component, but it does. Animal Diseases Act, which was actually now replaced by the Animal Health Act, but they have not yet repealed the Animal Diseases Act in full, and the Animal Health Act isn't entirely in operation yet. So that's sort of, I'm not quite sure what the reason is. I left the Department of Agriculture in 2002, so that process was ongoing by the time that I left, so I'm not sure what the reason is why it has not yet been fully implemented. But obviously that deals with all kinds of animal diseases. And like I was observing earlier to someone, is that the reason why we had border fencing in the first place wasn't to keep our people. It was to stop animals from crossing borders for purposes of animal diseases control. Even now we have what I call the red line for something like for horses. There are certain diseases of horses that is not prevalent in the Western Cape, but it is here. So you're not allowed to take horses from there. Same with bees. The other thing where animal diseases also has a component of animal welfare, I always find it ironic, is that foot and mouth disease is not deadly for people. People can get it, they can contract it. It's not deadly. But if foot and mouth disease is picked up in a herd of animals in an area, they kill everything, all the animals. It's a total burn. They just kill everything. And the reason why they do it is to protect our export market. Nothing to do really with human health. It's economic. It's because foot and mouth disease is highly contagious. The people that work at the Onderstepoort Biological Products Laboratory are not even allowed to visit farms and agricultural shows. They have to shower in and out when they enter and leave the facility. That's how contagious it is. And that's why they kill all the animals, stop exports for a while, because no country will touch your animal products if there's a possibility of foot and mouth disease. Okay, so the Animal Health Act is the successor of the Animal Diseases Act. It was mentioned the Societies for the Prevention of Cruelty to Animals Act. The National Party government at the time passed, I think, something like nearly 300, in excess of 200 bills in 1993. I think they were literally rushing to get things through before the new government came into power in 1994. And I think this was the reason for this, that the animal welfare legislation was transferred to the Minister of Agriculture. And you may recall that the Government of National Unity version 1 happened at that time. The Minister of Agriculture was still Cry van Niekerk, the old NP minister, so very little changed. And that was the time when I was working there, so very little changed that time. Okay, Animal Improvement Act is about breeding practices, which can also entail very cruel practices. Meat safety we've referred to, and the animal welfare issues that's specifically relevant under the Meat Safety Act is things like the codes for the transport of animals. That was the last piece of legislation that I put through Parliament when I was still working there. And we tried, one of the reasons why the system was changed is to allow, we had the Cato-Rich Abattoir here in Johannesburg, and they could slaughter 1,000 heads of cattle a day. So you can imagine the number of animals, and one head of cattle is one unit, and I think it's 4 sheep is 1 unit. So if we talk about 1,000 head of cattle, it translates to several thousand sheep and pigs and goats, smaller animals. And one of the reasons why the Meat Safety Act has a different approach, it allows smaller abattoirs in various places, instead of having these massive abattoirs only in the metros, what today are the metros, and all animals have to be transported there. There was an attempt made to rather have smaller abattoirs, make it possible to have smaller abattoirs all over the country so that you don't have to transport animals over these vast distances. And the Animal Identification Act, why that's in there, that's branding. That's where they take a hot piece of metal and put it against an animal to brand them. It's really about the registration of the branding, the symbols and the registers and so on. Oh, I must just check my time. I'm carrying on here. Until what time do I? 5. Okay. So that's, there could also be an element of cruelty there. That's why I listed it here. I'm not that familiar with the legislation under the Department of Forestry, Fisheries and Environment, and isn't it so typical that the environment comes last? But under them, there's the National Environmental Management Act and the National Environmental Management Biodiversity Act, which is really about, the non-domesticated animals. And I'm very worried that I now want to change the status of wild. It must now become almost like a domesticated animal where you can slaughter them. I'm worried about that. And then obviously the provincial legislation where they look at things like nature conservation, the permits for keeping and transport of animals, which is mostly done by the provinces. Reasons for law reform, constitutional imperatives. There's a lot of provisions in the Constitution that requires laws to be developed, like the Public Protector Act and the National Prosecuting Authority Act and the Auditor General legislation. All of them, the Constitution requires that this legislation be developed. Case law often requires you to amend your legislation. Talking about children, there was the adoption of children was changed completely after 2 significant court cases. The possibility for same-sex couples to adopt children, and for unmarried fathers to have to give consent when a child is adopted because it wasn't required before. International agreements, it was mentioned that the animal welfare international legislation, international agreements is not applicable. It's applicable among states and interstate organizations. But if you want to apply to your citizens, you have to domesticate it. You have to adopt it into local legislation to make it enforceable. And mostly when you accede to it, if you ratify an international agreement, part of that ratification requires you to adopt legislation to give effect to it, but you usually get quite a long time to do it. So sometimes it can take 20, 30 years before it actually happens. Societal changes, okay, so some of there twice. Technological development, something like the Protection of Personal Information Act. A lot of it has to do with, you know, the new electronic era that we live in and the accessibility of information. You have to update things. Sometimes things change. But here is something that I just wanted to highlight. What's important when you adopt new legislation? You must be very clear about the objects and the aim of your legislation. Legislation must have a legitimate purpose, and the way in which you apply it must give effect to that legitimate purpose that the legislation has. You must be clear about the responsible minister and department. You need an implementing agency. That's probably one of the biggest problems in the animal welfare space, is that there's no clear lines. I know that the NSPCA were given, but they're not the only organization in this area. So one must maybe look at how that can be addressed. And that's where I want to make the link to the Children's Act. The Children's Act is a mixed act. Part of it is under the National Department of Social Development, and part of it falls under the provincial departments. But a lot of the work is not performed by either of the departments. It's performed by the welfare organizations, family welfare and child welfare organizations. So the organizations are recognized. They have to comply with certain requirements. People working there has to be, you know, registered social workers, which also under their legislation has to comply with requirements, must have the necessary qualifications. So it's something that one might consider. And if you want to give formal recognition to maybe animal health people, the Veterinary and Paraveterinary Professions Act is probably the most suitable act, where you can formally recognize other professions in animal welfare. Okay, yeah, and then obviously in such legislation, you will have enforcement provisions and your requirements and qualifications that people have to comply with. And then the other thing that I wanted to mention, somebody asked me, so I added this quickly, about a cooperation. Is it possible for different departments to cooperate? I know. This is important. Yes, you can. Under the Children's Act, the Department of Social Development and Justice, it's formally under the Minister of Social Development, but there's chapters in the Children's Act which is actually administered by Justice, so it's possible. The Marine Living Resources Act, it was one of those when the departments changed, where bits and pieces of people and budgets were passed over, so you can do that. And also under the Children's Act, you have the cooperation between the departments and the welfare organizations. Okay, and then just Law Reform Commission, we do law reform, but on a bigger scale, if there's nobody else to do it. And in this case, I don't think we will be interested because agriculture is already in the process of reforming the law. And there is information that people had asked it. Okay, thank you. Oh, one last point. Policing versus compliance. You cannot enforce legislation by just trying to police it. People must want to. Look what happened with ETOL. People must want to comply because you can't be everywhere to police it. You have to get buy-in. And that's how you get legislation successfully applied. Thank you.